Now we're gonna go on to oil and gas mineral liens. And what I kind of want to say about oil and gas mineral liens before, because I don't, we're already at 12:40, is that chapter 56 of the Texas Property Code covers oil and gas mineral liens. They're specifically just for oil and gas mineral properties, which obviously is very big in Texas. I mentioned that there are a lot of other states that do that have a separate statute just for oil and gas mineral liens as well. Clearly it's going to be in the states where there's a lot of oil and gas. But the legal requirements and the procedures, like everything we've talked about, is going to be very, very similar to M&M liens. We're going to have a deadline we have to file, and we're to file the lien in the property records, and we're going to have some notice requirements depending on if we're a subcontractor or not. And generally in Texas, there's not a whole lot of case law about oil and gas mineral liens. There's a lot, but it's not anywhere near as much as M&M liens. And so a lot of the times we're kind of going off of cases and precedents based on Chapter 53 and the M&M lien statute rather than oil and gas mineral liens, because there's just not really a whole lot of precedents for us to go off of. So really, even though these are two separate and distinct statutes, they really are interconnected. Okay, so I'm going to go over who is entitled to a lien. And in the code, it talks about the different contractors that are entitled. And so these are the definitions. The first one who's entitled to a lien is a mineral contractor. Okay, this is very similar to a GC or an original contractor under Chapter 53. So it's a person who performs labor or furnishes material used in mineral activity. And it says under an express or implied contract with a mineral property owner. So we have to really look at what each of these definitions mean. Also, a mineral subcontractor can also file a lien, who is entitled to a lien, and they are like your normal subcontractor. However, here in this statute, there's not two different tiers. We're just going to have one tier of subcontractor, and they are a person who performs labor or furnishes material used in a mineral activity under a contract with a mineral contractor or a subcontractor. Okay, so then we have to ask ourselves, what is the mineral activity? Well, mineral activities are digging, drilling, torpedoing, operating, completing, maintaining, repairing. I didn't list out the whole statute, but it's an oil and gas well or a pipeline. I'll go over those different types of properties on the next slide. But here's probably the most important part to remember about oil and gas mineral liens, and that is, what is a mineral property owner? So what I've seen a lot in my practice for people who are not as well versed in oil and gas mineral lien law is that they will actually, a mineral property owner is an owner of land, oil, gas, or other mineral leasehold, okay? And a lot of people will put the fee owner here on their liens, and that is incorrect. So if there's anything you guys can take away from this talk today, it's that the mineral property owner in a Chapter 56 lien is the lessee of the oil and gas lease, so the oil company. Okay, they are the owner of the fee simple to determinable. That's what that's who the statute is talking about here. So the lien does not attach to the fee interest, and you don't have to go find the owner of the property who owns the minerals of the land the way we think about in fee simple. No, it's actually the oil and gas company who has leased the property from the lessor or the owner of the minerals. So that can be very confusing because of the way the definition is, the way, I guess, the name of the party, the way this is defined, mineral property owner, that's very vague to me. I kind of wish that was that term was a little bit easier to understand. And you'll also, however much everyone here knows about oil and gas law, this is the owner of a land, oil, gas, or other mineral leasehold. Well, we remember that, from property law, that the term lease is misleading because an oil and gas lease is actually granting title to the mineral estate, okay, for the term of the lease, right? That's the fee simple determinable. So they actually do own title to this property. And so that's why the lien attaches to this owner, whether it's Exxon or if it's BP or whoever owns this mineral lease, and to the actual leasehold itself. Okay, this was what I was talking about, the property that's subject to the lien. This is straight from 56.003. So it's the material, machinery, and supplies that are furnished or hauled by the lien claimant, the land, the leasehold, the oil or gas well, the water well, oil or gas pipeline and its right of way, and the lease for oil and gas purposes. Okay, so that's a lot right there. We've also got other material, machinery, and supplies used for mineral activities and owned by the owner of the property listed in subdivision in 2, right? This is also very vague. We don't have a ton of case law or precedents under what this actually means. Material or machinery, there's a lot of stuff. I'm sure for any of you that are involved in the oil field, there's a lot of stuff out there on these leases, and things are coming off and things are coming on all the time. And then number 4 is also very important because it says other wells and pipelines that are used in operations related to oil, gas, and minerals and located on property listed in subdivision 2. This is such an important part of the statute because basically what it's saying is that if you have a lien, for instance, if you have a lien on a large lease, if you've provided services to a really, really large leasehold, maybe it's 640 acres, right? And you've worked on one particular well, say it's the ABC well number 1, and we get this information from the Railroad Commission. You will also, if there's other wells on that leasehold, you will also have a valid lien on the other wells. This is great in an instance where maybe one well is doing really, really well out on a lease, and it's just doing well. It's making a lot of money. And if the other one maybe isn't doing so well, or something happened to it, or there was just issues with it, you're going to still have a valid lien on that other well that is doing well, that is doing, and making a lot of money. So that is a really important part of this statute. Okay, so for securing a lien, this is the deadlines. The deadline is not later than 6 months after the day the indebtedness accrues, which for that it is the last date of work. And so that lien has to actually be filed person claiming the lien must file an affidavit with the county clerk of the county in which the property is located. So they have to be 6 months after the last date of work. Now, one thing I always like to mention here is a lot of the times I've been in a lot of situations where there's a leasehold that covers different counties. Say it's 2 counties. The lease is just, kind of straddling over 2 counties. You have to file that affidavit in both counties. So remembering that is super important. Now we're going to talk a little bit about the notice requirement. This is clearly, the notice is only for subcontractors, and it's much simpler than under Chapter 53. And what it is not later than the 10th day before the day the affidavit is filed, a mineral subcontractor has to send notice to the property owner. So basically, 10 days prior to filing your lien, you need to send that notice to the property owner, and that's it. That's much more simple than under Chapter 53. But obviously, that also means that you don't actually have a full 6 months. You have, 5 months and 20 days, because you've got to make sure that you get that notice sent and then have time to file the affidavit. This next slide is about what has to go into the affidavit, the contents of it. A lot of similar stuff to Chapter 53, the name of the mineral property owner involved, the name and mailing address. Like I said, the mineral property owner, that we talked about, is the lessee of the oil and gas lease. The name and mailing address, the dates of performance, so the dates that they were actually working, a description of the land, leasehold, interest, pipeline, or pipeline right-of-way. What you're going to want to get here for that is a lot of our clients have a specific well they've worked on, and this should be on the invoice, hopefully, or they know where they worked. And you're going to have to go get that information from both the Railroad Commission, if we're in Texas, and also from the property records. For number 5, they have to do an itemized list of the amounts claimed. And then if you are a subcontractor, then there are 2 additional requirements. You have to name the person, the name of the person for whom labor was performed or material was furnished. So basically, the general contractor, the original contractor. But then you also, this is really important, you have to make a statement in the lien that the subcontractor timely served written notice, and that the lien is claimed on the property owner or the owner's agent, representative, or receiver. This is, it's a little bit weird, but you actually have to say this in the affidavit, that your notice was timely served.